Right, welcome back, and let us continue with this discussion on the impeachment trial of the hearing of Deputy President Rigathi Gachagua that is ongoing at the Milimani Law Courts. And with me, of course, I'm still joined by Eliud Ngoge, a lawyer. And Eliud, yesterday we saw a Deputy President appeal the empanelment of the three-judge bench by DCJ, Philomena Mwilu. The biggest question now perhaps could be, should this particular judge bench issue a ruling and say that in their ruling they lift the conservatory orders, and then the higher courts say that you have no right to be listening to this particular hearing? What will then happen?
Well, if you are not properly constituted, or rather the authority, appointing authority was not proper, didn't have instructions to maybe appoint you to become, to be the free bench to hear the case, and you end up making a decision, then it means that the decision that you have made becomes, does not hold.
So what if Kindiki is sworn in? What will happen?
And that's why we are seeing everything moving so fast, because one is an appeal ongoing right now that has, or rather, that was filed yesterday, and we expect to get the information on whether it's being allocated any dates to be heard. Then we already have this one on lifting the conservatory orders. If the conservatory orders were to be lifted, you know, there is a process by which this whole process has to follow. The legal process is, we expect that there is the gazettement of impeached Deputy Gachagua from being the Deputy President of the Republic of Kenya, and then there should be another gazette issued gazetting Professor Abraham Kithure Kindiki as the Deputy President of the Republic of Kenya.
Without public participation, you may ask?
So, we are saying, if the conservatory order right now was to be lifted, that's the next move that we expect from the President. So that would be the next move. And once it is gazetted, the swearing process takes place. But I believe the judges are likely not to hold that decision or to uphold that conservatory order, because there are questions on how the process, the procedure was held at the Senate and at the National Assembly. Was there public participation? Remember in a few years back when we had the handshake conversation, the BBI case, where we went all the way, the case went all the way to the Supreme Court, and the court found that there was no proper public participation. The initiation of a process of amending the Constitution was not properly done, where the members of the Republic of Kenya were the ones to initiate it according to the law. They are the ones who are supposed to initiate it. But in this case, there were a few individuals who went ahead and initiated the process. And so public participation is not as simple as we may want to disregard it. Someone in court said that this is not child play, that the process of impeaching a deputy president should be taken with the seriousness by which it holds. And so part of the seriousness under Article 118 of the Constitution is that there must be public participation process being carried out. And so whenever the Senate, whenever the presidency has to go through the process of appointment. So that public participation has to be held, has to be taken seriously for the people of Kenya, who are supreme under Article 1, to give their views. And in this case, the form that was given to the people of Kenya, for example, only had 3 questions where you are to pick. And it did not have the response from the Deputy President, Rigathi Gachagua, stating his case, for you to be properly informed as the process was to go on, for you to make a proper decision as you receive these forms, whether he should or should not be impeached. And so public participation is a major issue, and so I do not foresee, I don't foresee at all the lifting of the conservatory orders.
All right. Finally, before we close, moving forward, this particular impeachment case of the Deputy President, former Deputy President, Rigathi Gachagua, does it prove that, you know, it's even so easy to now impeach a sitting president, if those are some of the, you know, charges that can make a deputy president to be impeached? What does that really tell us into the future?
Into the future, We can only wait and see if tomorrow or the day after, if a bench presided by Honorable Eric Ogola goes ahead and makes a ruling and says that we do not find that the conservatory orders should be lifted. If that is the decision, or if they find that they should be lifted, we have to wait and see their reasoning, because we have said this case is momentous. This case is one that is, he would say in class, Justice Ogola would say, grundam. It's one that has so much force that we, as the people of Kenya, we can only wait to see the reasoning of the judges. And in making that reason, or giving that ruling, it has to also inform the future, what we call a precedent. It has to carry so much weight that in the next cases of impeachment processes, we will keep referring to the decision of a three-judge bench, referring to this process. Was it properly done? What are the days to be given to the parties? Should the impeached party be given a right to be heard? What happens in case they are unwell? So all these decisions need to come into play when this ruling is being issued. And so we can only wait for the decision. But also, this is not the finality, because we're going to have, again, hopefully, the parties who might be unhappy might move on to the Court of Appeal and decide to appeal this decision. After that, the party that will be unhappy might move to the Supreme Court and decide to challenge that decision, and the Chief Justice and the Deputy Chief Justice are going to make that major decision that is going to impact our lives as Kenyans on impeachment process.
So clearly it's a wait and see.
It's a wait and see process. We cannot conclude this issue today and expect that there will be a public holiday. Because I know a lot of Kenyans are expecting a public holiday with the swearing in of the Deputy President nominee.
All right. Well, that particular hearing, like I said earlier, is supposed to resume at 3:30 p.m. And as you can see there on the screens, lawyers are actually streaming in, meaning that the hearing will start any moment from now. As you can see there, that's the Milimani Law Courts here in Nairobi. The sitting is supposed to commence at 3:30 p.m. Earlier on during the day, we had petitioners raising pertinent issues in regards to the lifting of conservatory orders of a deputy president, or former deputy president, conservatory orders, rather, stopping the swearing in of deputy president-elect, that is Abraham Kithure Kindiki, as well as they're arguing the case on that particular process, how it was conducted, saying it really happened in a hurry. 1 minute this is happening, next minute that is happening, last minute, nomination of Kithure Kindiki there. But of course, that is a case that we are keenly following on. When we resume at 3:30, the respondents are going to be arguing their case. That is the lawyers of Parliament, the lawyers of Professor Kithure Kindiki, and so on and so forth. Those are going to be coming in later at 3:30 p.m. As you can see there. The session is set to commence anytime from now. Lawyers are set in there. What perhaps are we expecting in this afternoon? Perhaps, Eliud, if you can talk to us about it.
What we expect in this next session is, you, as an applicant of any application in court, when you argue your application, you get a response from the other party. Once they respond to that issue, you're given the right to answer whatever they have responded to your issue on. So we now expect the lawyers for the AG, for the President, for the Senate, for the National Assembly to come in and now give responses, because remember, the lawyers for Deputy President Gachagua have already punctured their case. They have raised the issues and said, no, the process was not properly done. There cannot be any vacuum if we have to wait until the full all the petitions are heard. They have argued and said that if in any way we are going to raise, or rather, the conservatory orders are going to be removed and proceed to swear in the Professor Kindiki, they have argued and said that the process was not properly done, and their cases, the petitions which they have already filed, are going to end up being an academic process, which basically means that they can only be referred to by law students on the process, but they will not have any effect at all to the common mwananchi and to their clients. And so we expect them to come and now answer to all these to all these holes which have been punctured. Let them tell us if there will be a vacuum. What is the interpretation on that? What is their response on that issue? Let them come and tell the court whether, if the conservatory orders are lifted, their cases will be an academic exercise. And so we need to convince the court this afternoon, and the court will be expected to sit back and retire in their offices with their researchers, compare notes, what they have written while they are listening to the two parties, and make a decision, a ruling on whether to lift the conservatory order. So I expect these lawyers to come out strongly, the lawyers for AG to come strongly and argue back and respond to those issues.
The morning session, if you follow it closely, Senior Counsel Paul Mwite was poking holes on the public participation exercise that was conducted by Parliament, and they were saying the numbers are not adding up. Because perhaps they were saying that the total number of persons in a certain constituency totaling to the ones opposing and the ones supporting it are totally different. That is also what the lawyers of the National Assembly are up to, perhaps to deliberate on? So
we need to justify. Because I heard Advocate Elisha Ongoya argue and say that, for instance, there was a station where there were 70 persons who voted yes, but the station had only 40 people who participated in the process. And so what is happening to the math? The math is not mathing.
It's not mathing.
Using that lingo that we use in the streets. And so we need to hear genuinely, are the stations which were being referred to for on public participation part of this case, and are they going to affect? Do they feel that they conducted a public participation? Do they feel that the Constitution does not require public participation when it comes to the impeachment process? Do they feel that the timeline given to the members of the public, because remember, the adverts were put in place, and 2 days later, then the responses were put in from the members of the public. Do they feel that that is what the proper process of impeachment should be? And so these are the responses that we expect from the lawyers for the AG and from the from the president to come in and respond to those issues.
So the AG is supposed to convince the judges why they should actually, lift these conservatory orders and have Abraham Kithure Kindiki sworn in?
Yes, they need to show us. Again, the other issue was the urgency. The lawyers for Gachagua are raising the issue of this matter is being rushed and we need to take some time to discuss it. We need to give a fair hearing. We need to give fair trial to the impeached person. And so we need to argue, and we expect him to come in and argue and say, no, he was given a chance. By us making this decision, by Senate making the decision to proceed and vote upon the impeachment, they actually made a decision. They gave him a fair trial. He was given a chance. He did not show up. His lawyer, there are some corners which have argued that since senior counsel Paul Mwite was in court, then his existence in the court meant that he should have been the one to represent. He was already representing his client. He should have proceeded to argue and go through the hearing process rather than try and stop it and postpone it to another date. So this is quite interesting to see how they are going to come back and argue and say, no, you are given a proper chance, and therefore the holding by the Senate and the probable nomination of Professor Kithure Kindiki was proper, was properly done, and we do not need to wait for 70-something days for this process to be concluded. So they are coming to tell us.
And that is what the lawyers of Gachagua are arguing on, because they're saying, what is the hurry for? It looks like a predetermined process of actually having this man sent home by, maybe the government.
It's quite interesting to see that. And even individual petitioners who have filed this case. There's a lady, I believe, Wanjiko, who was in court this morning, and a doctor petitioner who has also filed a case. And this just encourages us as Kenyans that we don't have to wait and instruct a lawyer to appear in court on our behalves to challenge some of those things. That you, as a Kenyan, you could sit back, draft your own petition where you feel that your constitutional rights have been infringed upon. The constitution has not been followed through. This is very encouraging to see that the constitution has already empowered you as a Kenyan to wake up tomorrow, put in your application, put in your petition, and say that, you know what, I elected this person, or I'm a Kenyan, and I feel that there should be a proper procedure being followed when it comes to impeachment. So that's very encouraging to watch.
So you don't need a lawyer?
You don't need a lawyer. When it comes to public interest cases, when it comes to constitutional matters, you do not require a lawyer. The Constitution already empowers you. You can draft your own petition and appear in court and state that your right as a Kenyan is being infringed upon, that you want to be heard as a Kenyan without going through legal representation. But because the lawyers are the ones who have gone to school, it will be also in order for you to go to a professional and allow the professional also, because they know how to argue and how to go about that, allow them to argue on your own behalf as a Kenyan. Yeah.
All right. And let me take you back to the nomination of Abraham Kithure Kindiki, who is, I don't know whether he's still the Interior Cabinet Secretary. What does the law say about that? Is it that the president is supposed to gazette a notice notifying Kenyans that have received a resignation letter, or Kindiki has tendered in his resignation letter as, you know, a CS, and so what's supposed? How is that supposed to be gone about?
Some quarters have argued and said, according to our Elections Act, a public officer, before they vie for office, they need to resign from that office. And this other quarter is also arguing, there's another quarter that is also arguing in saying, because the Constitution itself, the plain reading of the Constitution, Article 148, does not require all these other procedures to be done. The plain reading is that the president, upon a vacancy coming up, he can nominate and send the name to Parliament, National Assembly, for National Assembly to vote on this person. And so it doesn't matter. And that's the gap that we are seeing. That's the vacuum we are seeing, and the kind of interpretation that we need this court to give to us. That what happens? Do we still need to look at the nomination of deputy president as if it was an election process, or do we need to look at it as if it's just a prerogative of the president to wake up tomorrow and say, hey, you are qualified, I like you, I think we can work together, yet you're a public officer, or you are, let's say, you do not qualify to serve under that office. So these are some of the issues that need to be clarified by this court.
But where does the weighty issues, where do they put the nomination of Kindiki? Because there's so many. We're having the IEBC, we're having, again, there's supposed to be public participation from Kenyans to, you know, approve or just air out their views for this nominee and so on and so forth. Where does that put the nomination of Kindiki?
Well, it puts it in a very questionable manner because, and that's the argument in court, because one, we're saying there's no proper procedure. We do not have that proper procedure on the vacancy of the Deputy President office. It's not clear. We don't have a sub-legislation or a subsidiary legislation apart from the Constitution for us to look at and say, okay, this shall be the steps that shall be taken. We don't have that. What we have in place is the plain reading of the Constitution, but when we look at the wider reading of the Constitution, for example, what I was saying earlier, Article 118, Public Participation, Elections Act on the candidate and how to go about the appointment for this office, and the documents that we now see were presented, the memoranda that was presented to the president. When we look at this, then it becomes questionable how the process was done. How at the middle of the night, did we have some offices operate? How do we have a body by the name of IEBC, which is not properly constituted, making a decision?
Can't the secretarians
Yes.
do that? Does the Constitution allow the current secretarians to do something like that?
The court has, remember when we had the presidential petitions in 2022, what was being argued in court was on the major issues to do with the returning officer for an election of a president. And the chairman of IEBC is the returning officer when it comes to the election of a president and the deputy president. As we stand, or as it stands, we do not have a properly constituted office, IEBC office. If today I was to ask you who is the current chairman of IEBC, because the previous chairman resigned in January 2023.
Yeah, his term came to an end.
His term came to an end.
Yes.
Or rather, he retired because his term came to an end. And so, what happens is we do not have a returning officer for the election of the deputy president and the president. And so, as it stands, then it's improper for us, or we question how this process to vet some of these documents.
So the legality
was done. Yeah.
The legality is now what?
It's questionable. And we go back to the judges, and as it was said by Advocate Elisha Ongoya, that we look to the mountain, we look east of the mountain. And that's what Deputy President Gachagua needs to do. Look to the east of the mountain and just pray that this court will grant him justice.
All right, like you had said earlier, this is just a wait and see to see how that particular case is going to go about. But as you can see there on the screen, a moment from now, the lawyers are gathered in, they're settled, they're just waiting for the three-judge bench to see to that they can commence that particular sitting that is set to resume at 3:30 p.m. on the hearing case. Remember, the AG is seeking to lift conservatory orders stopping the swearing in of Deputy President-elect Abraham Kithure Kindiki. We are keenly following that bit, but we are now going to take a very short commercial break. But don't go too far, because we'll be back with more.